Muy buenas tardes, muy buenos días, perdón. Bienvenidas, bienvenidos. Muchísimas gracias por estar aquí. Disculpen los minutos de atraso. Una vez más tuvimos un temita con nuestra amiga Zoom, pero aquí estamos. Quisiera presentarles a la abogada Linda Hoffman. Linda Hoffman va a tener la amabilidad de hacer una presentación sobre una serie de cambios que ha habido para las visas que reciben las personas que se retiran de la OEA. Como esta situación es delicada, es complicada, no es fácil entender lo que está ocurriendo, lo que hicimos fue contactar a Linda, que ya dio una charla disculpen, pero estuve un poco enferma, dio una charla en el Banco Interamericano de Desarrollo sobre este tema. Lo conoce muy bien, así que le voy a pedir a ella que haga su presentación y luego habrá un espacio, por supuesto, para las preguntas y respuestas que puedan tener de parte del staff. Linda, si estás ahí, por favor, si pudieras activar. Linda, sorry, Linda speaks in English. She will do her presentation will be in English. We have interpretation today, so whoever wants to hear in Spanish, you can connect to that channel. And yeah, without further ado, Linda Hoffman. Linda, are you there? Hi, welcome. You are in mute, Linda.
I'm here now. The link wasn't working, so as
Yes.
you know, I couldn't get in.
Yes. We had trouble with Zoom, so we had to send a new one. We apologize for that. You're here.
That's okay. I'm just glad it all worked out. Well, good morning to everybody, and I'm thrilled to be here. I've only spoken to the OAS a couple of times, and I'm happy to be here this morning. There's a lot of material to cover. The idea of this seminar is not to obviously address everybody's personal situation, but to give you information and things to think about as you plan after retiring, whether you're going to stay in the US or go back to your home country. So there are lots of things that you need to know. And I'm going to go through the material and then we'll save questions for the end. Hopefully along the way, I'll have answered some of your questions, but if not, that's the time, then I'll try to answer them when we've gone through the material. So let me start out by just reminding you about a few things that you need to understand when you're no longer a G-4, okay? When you retire or leave the organization, you and your dependent family members have a 30-day grace period in which to pack up and leave the United States, or if eligible to do so, file for another status in the United States, okay? That 30-day period is not a period in which you can still travel on your G-4. Your G-4 visa, whether it's valid in your passport or not, well, I mean, if it's still valid in your passport, it's not valid for travel once you've retired or left the organization. So sometimes people think because their visa looks valid on its face, even though they've left the organization, it can still be used, and it cannot. So it's very important you understand you can't travel any longer once you've left the organization. And this is true for your dependents as well. Also, work permission for a dependent comes to an end at the last day that you're a G-4. So that's important to understand as well. If you have a G-5 in your household, he or she, the domestic help, does not have a grace period, and you need to make arrangements for that person before your last day. Either they get another family to work with, or they're eligible to file for another visa themselves, or they just go back to their home country. But you have to think about the G5 as well, because they have no grace period. Now, before we talk about green cards, I want to say a couple of things about that 30-day grace period. Some people are not interested or not eligible to remain in the United States. However, the 30-day grace period may not be enough time for them to wrap up their affairs or, have medical appointments or whatever. There is the ability to file to change your status in the US to a visitor status. This is not a visa. This is a new status, a new I-94. And I think you all know what that is. The I-94 is the entry document you get when you come into the US. But this is a change of status that you file with both the Immigration Service and the Department of State to request up to 6 months to remain in the US. You're not leaving. You're asking for 6 months to remain in the US before you do leave to wrap up your affairs or whatever personal issues you have to deal with that can't be done within that 30-day period. So there are ways that you can remain in the US, not as a green card holder, but as in a non-immigrant status. As you know, a G-4 is a non-immigrant status, and there are other non-immigrant statuses that you may be eligible for to remain in the US, even though you may not be eligible or want to stay as a green card holder. But if you're going to file to change your status, you need to remember that you only have a 30-day grace period for those non-immigrant applications. If you don't do it within that 30 days, then you cannot do it. And of course, you could leave the country and come back in as a tourist on a V visa. If you're from a visa waiver country, you can come in for up to 90 days. And we can, I'm happy to answer questions about this later on, but I just wanted to let you know that there are ways to remain in the US possibly, even though it may not be as a green card holder. Okay. So I'm going to sort of change the order in which I do the green card discussion, because as you all are aware, there's been a big dramatic change in visa availability quite recently. And so I want to sort of talk about what that means before I talk about the classifications and the documentation that you need for those particular classifications. In filing for a green card, okay, there are two things going on at the same time, okay? One is with every green card application, there's a petition that goes along with the request for the green card. It's a petition either to file and classify you as a retiree. It's a petition to classify you as the parent of a US citizen or the spouse of a US citizen. There's a petition if you went through employment, you were sponsored by an employer to do a job. So every application for a green card has a petition, okay? And in the way that visa numbers are allocated in the US, every nationality and every type of classification, there are visas allocated for that classification, okay? There's an exception, which I'll talk about later, but this is what's important. So the G4 special immigrants, whether they be kids or retirees, are part of what's called the employment-based 4 classification. Special immigrants are put in the employment-based 4 classification. And visa numbers are allocated for that classification every year. There's a finite amount of visas that are allocated, and every year the new visas are issued when the fiscal year begins, and there's X number of visas, and they're divided up among all the employment-based categories and the family-based categories. And what happens is if there's a high demand in a particular category, then a queue starts, a queue develops, okay? So what has happened is there's a high demand for special immigrant visas, which has resulted in a long line. So the line now is back to September 1, 2018. okay? And what that means is that if you retired today and you could file the I-360 petition to get your place in the line, but you can't file the actual change of status for a green card because there's no visa for you. And that's the issue, okay? The issue is while you can get the place in line, and we'll talk about that in a minute, you can't actually make a change of status. So this is a big problem because people who worked in the international organization community for 25, 30 years were counting on the ability to stay here. And now because of the visa numbers regressing basically about 5 years almost, the second part of that application can't be made. So you either have to look at other ways to stay in the US or other ways of getting a green card, or you have to leave the country. So this is the issue that we're facing right now. And that problem, you know, has to be addressed on a larger level by the organizations, to the Immigration Service, because, you know, there's no easy fix unless there's some effort to try and increase visa numbers or make a special allocation for G-4 special immigrants. You know, it's just a real issue. So that's where the problem is, okay? So you can file a petition so that you're in the queue, but you can't file the change of status at this moment until there's an immigrant visa number that corresponds to the date you filed your actual petition for the special immigrant. And that date is called your priority date or your place in line. So that's where the problem is at the moment, okay? So we'll come back to that, but I just wanted to try and lay out what the issues are and what the problem is. So those of you who aren't retiring yet and are retiring in a few years, by the time you're ready to retire, this may not be an issue any longer. But people who are looking to retire in the next several months, this is going to be an issue, and you're going to have to come up with strategies and alternatives to see how you can remain in the US, or, you know, how long it's going to take for you actually to get the green card, okay? So let me talk about the requirements for the special immigrants, which I think are important. I just want to clarify those as well. There are 4 types of special immigrants, all of them impacted by this regression or this queue for visa numbers. The first is the retiree, okay? So you're familiar with that, but I'll just reiterate the requirements. You have to have worked as a G4 with your duty station headquarters for at least 15 years, okay? That 15 years can be aggregated. It doesn't have to be a continuous 15 years. You could have worked 10 years, gone overseas for a duty station change for 3, come back to the OAS for another 5 or 6, and then determine that you want to retire, or you can aggregate time at 2 different organizations as long as it's G4 time. So you have to, 1, have at least 15 years total as a G4 with your duty station headquarters, okay? Number 2, when you file, you have to show that in the 7 years prior to retiring, you've been physically present and resident in the US for half of that 7-year period. Okay, so what does that mean? All right. For these provisions, the special immigrant provisions, there's a specific definition of physical presence and residence. It means that all of your mission travel and your home leave, vacation time, annual leave is not subtracted from your physical presence and residence. The only thing that's subtracted is when you have a duty station change. So people should not be concerned that they've had 20 missions a year or whatever while they've been working at the organization, because the Immigration Service does not subtract that out of your formula. The only thing they subtract is when you've had a duty station change or you're no longer at the organization. So as long as in the 7 years prior to applying, you haven't had a duty station change or left the organization for more than 3.5 years, then you would meet the 7-year, the 7-year requirement, as well as the 15-year requirement. So you have to have both. Okay, and I hope that's clear. You need 15 years as a G4 duty station headquarters. You also need to show that in the 7 years prior to retiring, you haven't been out more than 3.5 years in that 7-year period. And mission travel and annual and home leave is not subtracted. So that's important to understand. You also have to retire. This is very, very important. You cannot separate, terminate, any of those things. You have to retire. The Immigration Service does not define retiring. Retiring is defined by the organization. So if the OAS considers you to be a retiree under their scheme, then they can give you a certification that calls you a retiree. But if you are not retiring, then you can't apply. Okay, that's very important. It's not, retiring doesn't mean you get a pension. Retiring means that you, unless there's a link to retiring in your organization, but it's not the pension itself, it's the organization calling you a retiree and giving you a document that says so. So any other type of separation from the organization, you should not be filing as a retiree because it will be denied. Okay, that's very important. Now, the immigration law gives retirees who file under this provision 6 months to file. Okay, that's what the law says. So when you retire, you must file something within 6 months of retiring. So at this moment, the only thing you can file is the I-360 petition to stop the clock on that 6 months so that you're in the queue for the green card. Okay, so last year this wasn't an issue, but now it is. So people who may have no other way of getting a green card, it's very important that they file this petition within 6 months of retiring so they have a place in the queue. And when their visa number is reached, then depending on where they are, they can follow through with their change to immigrant visa or green card status. But the law only gives you 6 months to file that petition once you've left the organization. Okay. So you have the retiree, then you have the retiree spouse who can file along with the retiree. The retiree spouse doesn't have to meet the formula. He or she only has to be a retiree and file along with the principal alien, who's the one who has to demonstrate that they have made the formula to file under this category. Okay. Then you have kids. Now, kids are a little different. They only have to show that they've had 7 years as G4 dependents with their parents having the duty station headquarters. They have to show that 7 years between the ages of 5 and 21. And they can make that 7 years up to their 22nd birthday because they're still 21 until they're 22. But unlike retirees, even though they can't change their status right now, they can get in the queue and they can remain in the US as G4 dependents as long as the international organization allows them to maintain their G4. So they don't have the same issue as the retiree who has to find, another way of remaining in the US or has to leave. Whereas the G4 child who makes their formula can file, but again, all they can file is the I-360 petition with the evidence that they meet the 7 years between the ages of 5 and 21 and also meet the physical presence of being in the US for half of the 7 years prior to their application. But they don't have to worry about having to leave the United States and can just stay here as G4s until the time such as their visa number becomes current in the line. So the children aren't as much of a problem as the retirees are, okay? The other issue is the surviving spouse. There's a provision for G-4 dependent spouses where the principal has died in service. They can file for green cards as the surviving spouse. They have to show that they've met a formula of having been in the US for 15 years as G4s while the duty station of the principal was headquarters. They have to meet the same requirements as the retiree, showing that they've been here physically present for half of the 7 years prior to applying, and they have to file within 6 months of the principal's death. So there's also that 6-month issue. Again, all they can file is the I-360 petition. So that is, the provision for the G4 special immigrants, where now it's a bifurcated process with the petition and then the green card coming later, depending on when visa numbers become current again. It does make it difficult to advise people because, you have to, we don't have crystal balls, so we don't know when things are going to get better. We always have to sort of take the worst case, because if things move more quickly, that's great. But if they don't, we have to kind of figure out how people can manage this situation under the current delays with green cards. Now, if you're only eligible under the retiree provision, okay, then I mean we can talk about alternatives after we get through the whole classification system. But you may be eligible for a green card a different way, okay? Supposing you have a US citizen child over the age of 21, or you have a spouse who's a US citizen. Those are considered to be immediate relatives, and they're not in any queue at all, okay? If you have a US citizen spouse or a US citizen child over the age of 21, or you're a US citizen with a child under the age of 21, all of those are considered immediate relatives, and they're not in the queue. There's no waiting period. It's just the processing of the application. And you can file for a green card anytime. Even if you're a G4 at the moment at the OAS, if you have a US citizen child over 21, or you have a spouse who's a US citizen, I mean, they can petition for you at any point, okay? There's no a queue that you have to go into. So that's important. So that might be an important alternative for you, given the fact that the G4 special immigrants are now, have now regressed. So US citizens can also file for a unmarried child under the age of 21, as I said. US citizens can file for an unmarried child over the age of 21. US citizens can file for married children, and US citizens can file for siblings. However, these are all in queues. There's a quota for all of those categories. And those categories can be very, very long. For example, a US citizen filing for a sibling, that's about a 14-year wait for a visa today. So some of these categories are just ridiculous and don't, are not going to be helpful to you in making your decisions on what you're going to do if you leave the organization. Permanent residents, now this is important. Permanent residents can file for a spouse, and permanent residents can file for unmarried children over the age of 21 or minor children under the age of 21. And oftentimes, the permanent resident spouse or the minor child of a spouse visas are currently available. So that's something that you can look at. If you're married to a permanent resident right now, that might be a way you can get a green card if that person is not eligible yet for citizenship. So that's another possibility that you can think about if you're married to a permanent resident at the moment. That might be a way of getting a green card and being able to stay in the US. So I want to mention that. There's employment-based, where you're being sponsored, or maybe your spouse has work permission, and this the spouse is being sponsored by, or could be sponsored by, the employer, who needs to go through a process to show that there's no available American or green card holder in the metro area who can do the job. So there's a way of getting a green card through private employment sponsorship. There are self-petitioning ways of getting green cards called an extraordinary alien or a national interest waiver, where you show either that you reach the very top of your field or discipline because you've done conferences and you've published articles and you're considered by other people to have reached the very top of your particular discipline, so you can self-petition. National interest waivers are where you show that you're doing work that's of particular interest to the US government. So there are other opportunities or ways of getting green cards that you might be eligible for, that you could look into as an alternative to the retiree category. Now, the real issue with the unavailability of visas right now is people remaining in the US, for the retirees particularly. And so, you know, some of the solutions may be, for example, if you have a child who has gotten a green card through the special immigrant provision, who's still under the age of 21, okay? And you are ready to retire, you need to retire, and you have this issue of how you're going to stay here. Well, if you have a child who's gotten a green card through the special immigrant provisions, you may be eligible for what's called an N visa, which is a non-immigrant visa for the parent or parents of a G-4 special immigrant minor that allows them to stay in the US with work permission and the ability to travel until that child turns 21. And that is a way some people can stay. You can still file your I-360 petition, but you would be able then at the same time to change your status to remain in the US if you have a child that had gotten the green card through this provision and is still a minor. So that's something that could be helpful in planning. Some people will change their status to a visitor status to gain some time, what I talked about earlier, to remain in the US for 6 months and maybe extend that another 6 months to see if there's any movement with visa numbers under the special immigrant provisions. There are other non-immigrant visas that people may be eligible for. Canadians and Mexicans may be eligible to work as TNs under the NAFTA agreement. So, you need to sit down with an immigration lawyer if you're in the situation and see what options you have. There may be things that you're not aware of that you may be eligible for. So I think that's one of the points of this discussion, to think about other avenues that may be out there for you while you're waiting for the G-4 special immigrant numbers to become current, or at least to come up to where you have filed. So you need to, there may be other options that you're not thinking about that are there for you. Now, if you're in a situation where you are eligible to file for a green card because there's a visa number for you, or because you're an immediate relative and you have a US citizen spouse or US citizen child, then you can file the petition to classify you as a spouse or parent of a US citizen. And at the same time, file what's called an adjustment of status. That's an application that you make to remain in the US along with your petition. So you file your petition, and then at the same time, you file your application to adjust status. This is what people did before visa numbers regressed for the special immigrants. They filed a petition and the change of status. And the change of status is what allows you to remain in the US while you're waiting for your green card application to be processed, okay? And when you file to adjust status as, let's say, the spouse of a US citizen, the US citizen is the petitioner, is the one requesting the visa. So they have to show that they're a citizen, that you're their spouse, or they're your child if you're the parent. And they also have to provide financial documentation to show that if you ever go on public assistance, the US government will be able to come to the US citizen for them to be the ones to, provide your well-being. And it's a theoretical provision because most people, have their own incomes and their children aren't going to end up taking care of them. So at this point in this application process, it's just the ability to show that the petitioner, whether it's the son or the daughter or the spouse, has income to support theoretically the green card applicant. And if your child is in school and you're supporting them, there are other ways to bring income to show that there's income in the household to support you theoretically, if necessary, so that you can go forward with these applications. Maybe your spouse doesn't work, but you can still bring in your income or savings and other sources of income to be able to show that there's income in the household to go through the process. So adjustment of status includes the petition with the evidence of the relationship as well as the finances and the change of status. And I'm talking about family cases now. And when you file a change of status, you're under the auspices of the Immigration Service. So even though you may be still a G-4 working at the organization and you can continue to work, once you file the adjustment of status, you cannot travel. You must wait for the Immigration Service to issue a travel document before you can leave the country. And right now, that is taking about 8 to 10 months minimum to get a travel document. So if you're going to file for a green card through a provision that allows you to file now, please be aware that you're going to have a delay in the ability to leave the United States. So while you can work as a G-4, you're not going to be able to travel. So you need to think about that before you make this application. But if you do make the application, you're legally here, you're waiting for that travel document, you need to have the relevant documentation, you need to have your birth certificate, your marriage certificate, divorce decrees, you need to have all those documents. You need to have them translated, which you can do if they're not in English, okay? You need a medical exam with a public health physician. If you've ever been arrested, you need those documents. So you need to make sure that you have the appropriate documents to file when you are filing an application to change your status, this adjustment of status for the green card that I'm talking about. Right now, adjustment of status cases are taking a little bit more than a year, okay, when there's a visa available. We're taking a little bit more than a year, and the Immigration Service can interview you if it's a marriage case or even if it's the parent of a U.S. citizen. They have the discretion to not do an interview and just approve the case on the paperwork. So it depends on if there are any issues in the case, whether you'll be interviewed or not, okay? And at the end of that process, there's a green card, okay? Now, for those of you who are not eligible to adjust status because there's no visa number like for the retirees, there's a process, the other way of getting a green card is called visa processing, okay? And visa processing is when you cannot complete the process in the United States because, for example, there's a queue. So how does that work? That works where you file the petition. Let's take a retiree as an example. You file the I-360 petition. You get your place in line. You're not eligible to stay in the US because there's no other alternative for you, okay? Or maybe you are going to stay in the US for 6 months by changing to a visitor status to wrap up your affairs, but then you're going to go back to your home country. Visa processing is where eventually, when there's a visa number available, you're going to have your interview in your home country with the US consulate at the embassy in your home country. And between the I-360 petition and the interview, there'll be documents collected by the State Department in anticipation of eventually sending that file to the US consulate in wherever your home country is. But in the interim, okay, you can apply for a tourist visa in your home country. If you go back home, you can apply for a tourist visa. You can come back to the US and visit periodically, because there's no provision that prevents someone who is visa processing overseas from coming back in and visiting the US and leaving, not overstaying and going back home while they're waiting for their green card to be available through visa processing, okay? Visa processing is a different process than adjustment of status. It's done at consulates. There's no work permission. There's no travel permission because you're not here. You're living overseas and you're just waiting overseas for ultimately to have an interview at the US consulate. Right now, that could be a 3, 4, 5 year wait. If we look at the visa numbers currently, okay, that could be a several year wait. That can change because visas are allocated every year, new fiscal year. Numbers move forward as well as backward. So the long delay now may be shortened as we move forward, as visa numbers become available, or maybe there'll be some changes where they will be able to take out categories that are using up visas, make special provisions for juveniles who come across the border who are in the special immigrant category, and free up visas for everybody else. I don't know. But right now we have to deal with the situation that we have in front of us. But the point is, if you file a petition, you will still get your green card. It will just take a lot longer. Okay, I mean, and that's the reality right now, but there is a process. You can go back home and eventually you'll get the green card and be able to return to the US, but it's not going to be for a while. And that's, why you may be, need to look for alternative ways to get that green card until something happens that allows those things to move, more quickly, so that there's not such a long wait. When you visa process, the requirements are not the same as when you're in the US adjusting status. When you adjust in the US, the USCIS takes your fingerprints. When you adjust in the US, you're not waiting quite so long because obviously there's a visa number for you. When you're visa processing, there is no fingerprinting done. So at some point in that visa processing, you'll have to get police clearances from all the places you've lived for more than a year since your 16th birthday in lieu of having your biometrics done. For some people, that might be a lot of places, but it's doable, but it's a different process than doing it here in the US, okay? If you're visa processing, you don't have to sit in your home country for 5 years. You can go wherever you want, but you can go back to your home country to do the actual immigrant visa processing when the time comes. Okay, so it's a different process. It will take longer for the retirees, but that's where we are right now. Now, once you do have your green card, okay, once you do have your green card and back in the US, you have to keep your green card. You have to maintain your status as a permanent resident. And that means that you are primarily domiciled in the US. You're paying taxes as a US resident, okay? A green card is not a tourist visa. It means that you're living here primarily. Does it mean you can't travel abroad? Of course not. You can travel abroad for, a period of time, several weeks or a few months, but you have to remember that once you have a green card, your comings and goings is trapped because the immigration service wants to make sure that you are living here. So if you are out of the country for 6 months continuously on your green card, you may be stopped at a port of entry when you return and questioned about why you've been out for a continuous 6 months. And you may have to be readmitted. So you need to be careful about how long you're out of the country when you have permanent residence. People are stopped sometimes even if they've only been out a few months because they can ask you anything they want at the port of entry. So you need to be aware of that. And if you have a green card and you know you're going to be gone for a long period of time, or you're going to take a job overseas, okay, or you're going to be posted overseas because you're still working for an international organization or an international entity that has offices overseas. If you have a green card, what you need to do is file for what's called a re-entry permit. It's a document that's valid for 2 years, and you file for it while you're physically in the US. You can't file for it abroad. And you tell the US government, or USCIS, I'm going overseas for 2 years for the OAS, or I'm going overseas for a long period of time to help an elderly parent, or whatever it is. And it protects your green card, okay? Because if you're out of the country for a year and a day without a re-entry permit, and you have a green card, your green card is considered abandoned. And during the COVID period, some people were stuck overseas and couldn't get back because of COVID and lost their green card because they were gone a year and a day and did not have a re-entry permit. No special provisions were made for COVID for people who were stuck overseas by the Immigration Service. So a re-entry permit is like ensuring that your green card isn't lost, and it can be renewed, okay? So this is, but again, you have to be in the US to file for it, whether it's your first time or your third time. Now, let me talk about citizenship very briefly, and then we can, move on to questions and all that. After you've had a green card for 5 years, typically you can apply for US citizenship. You have to show that you've been physically present in the US for half of that 5-year period and never out for 6 months straight. So, even a re-entry permit will protect your green card. It will not protect your eligibility for citizenship. Citizenship is you're physically in the US for the required period of time and you're not out any one trip for 6 months or more. So you can apply for citizenship. If you're a male and you've had a green card and you're between the ages of 18 and 25 and you want to apply for citizenship, you must register for selective service. That's very important. It's considered bad moral character for males who are between 18 and 25 who have green cards not to have registered for selective service. Anyway, after 5 years, you can apply for citizenship. If you're a green card holder married to an American, and you've had that green card for 3 years and you've been married to the American for that same 3-year period, you can apply for citizenship after 3 years. And you have to show that you've been physically present for half of that 3-year period and never been out for 6 months or more, okay? When you're sworn in for citizenship, the Immigration Service takes your green card and gives you a naturalization certificate. And now you must get a US passport to travel in and out of the US. You cannot use your foreign national passport any longer in and out of the US. If you're from a country that recognizes dual citizenship, then you can maintain your home country citizenship and US citizenship. But you can't travel in and out of the US any longer on any passport but the US passport. Now, one more thing I want to mention before we open up to questions, because I'm sure your questions will be very useful and helpful to unpack all of this information. But what I want to say is that it's been my experience working in the international organization community for a long time, that many people who come to international organizations first came to the US on a J1, which is an exchange scholar visa, a J1, not an F1, a J1, J like in Jack, not F like in Frank, okay? And oftentimes the J1 was funded by Fulbright, USAID, your home government, I don't know. And you may have had a 2-year return home requirement attached to that J1, meaning that when you finish your degree, you were going to go back to your home country and take that expertise. Now, oftentimes people are recruited by international organizations, and they are allowed under our immigration law to go from a J1 to a G4, even if they have the 2-year return home requirement. It's allowed. However, the fact that you're a G4 does not mitigate the 2-year home foreign residence requirement, okay? So when you're done being a G4, before you can get a green card and a lot of other visas, you have to deal with the 2-year return home requirement, either by showing that you've been home for 2 years, or you're going home for 2 years, or going through a waiver process at the Department of State. Now, not all J1s have this, but some do. And every year I get 2 or 3 people who all of a sudden discover, oh, yeah, I have that problem. What do I do? So if that, you need to look at your documents. More importantly, you need to keep your documents. More people just get rid of their documents, and then when they need to deal with these issues, they have no information. So please make sure you keep your documents if they're immigration related. If you've had a J1, just check the documents to make sure that you don't have a 2-year return home requirement. Because if you file for a green card and you do, that green card will not be processed. So I just want to say that because, like I said, I find that situation always several times a year in the international organization community, and I just want to prevent people from making mistakes or getting denied because they didn't take care of something that needed to be dealt with. So there's so much more I can say, but you know, immigration changes, as you see, practically on a daily basis. So you need to be aware whenever you go into the immigration world to, you know, to make sure, are your fees correct? Are your forms the most current? Do you know where you're filing your case? Because cases get filed at different places. There's no in-person filing. Everything is sent to an adjudication center. You have the right address. Most importantly, talk to an immigration lawyer before you do anything to make sure that you're doing the right thing, that you know what you're eligible for, and you're not making any mistakes. If you file in the wrong place and the application comes back, you know, 8 months later and you're a retiree, you've lost that benefit forever because you didn't timely file. A rejected case is not a filed case, okay? So thank you for listening to me drone on. I try not to be confusing, but it's so hard not to be with this subject matter. So let me see what your questions are, and hopefully Thank
you, Olivia. This was so useful, so much useful information. I've been seeing in the chat of this meeting, there's several questions, and they continue to pile up. So I'll read it so that you can answer as concrete as possible, so that we can answer hopefully all of them. So someone asks, do your USA citizens' children need to be living in the US to be able to petition you?
Good question. Yes, they need to be domiciled in the US in order to petition for you, because the affidavit of support requirements must be by someone who's living here. But let me just clarify that with one caveat. A child who lives abroad for school let's say your child is just going to school abroad, but their domicile is still considered to be with you in your household. So a child living abroad for school is only there temporarily versus someone who's working and living abroad. So, you know, if your child is just going to school temporarily, but it's considered to be still a member of your household, that's a different situation, and that child may be able to sponsor you.
Thank you. Next one. Does the 15 years with a G4 combines staff and CPR years at the organization, or does it have to be 15 years as a staff? CPR is an external contract for us.
Being overseas?
Yeah. There's plenty of CPRs that work here in headquarters, but with a CPR and not with a staff contract, although they still have G4 visas.
Well, okay, so that's like a consultant.
Right, exactly, a consultant, yes.
Okay, well, the Immigration Service doesn't distinguish that, okay? So if the OAS says this person has been a full-time person holding a G4 and retired on X, if part of that is CPR and they're full-time, you don't have to break that out. So if you're willing to count it, then yes, that's fine. That could be counted as part of the 15 years, sure.
Thank you. That's very useful. We have a lot of CPRs. Next question is, can a US citizen stepson or stepdaughter apply for a step-parent?
Yes, as long as the step-parent relationship occurred before the child's 18th birthday.
Thank you.
Yes, so that would work, absolutely.
Great. Next question. If someone has a child who is a US citizen, but your spouse is not the child's parents, what are the options? I guess it's the same as the other question about the step parents.
If it's a step parent and the child is under 18 when you became the step parent of that child, then that US citizen child, as long as the child's over 21, clearly can sponsor you.
Okay. Can a permanent resident, can a permanent resident child apply for their parents?
No, only a US citizen child over 21. A permanent resident cannot sponsor a parent.
Okay. Can a wife of a G4 adjust status after having complied with the 15 years with the G4, while the G4 visa holder still work with the G4?
No. There is no provision for a spouse to do anything after 15 years. The only provision is for the retiree. If there's no retiree, there's no case.
Thank you. Someone asks, if the length of the queue when applying, when having an immediate relative, US citizen, children under 21, is shorter than the time left to be considered as retiree by the OAS, it seems like a good idea to start filing the petition. Is this correct?
I'm not sure I understand. Are you asking whether you only have to wait the processing time if you file as the parent of a US citizen?
Yes, I think she's comparing, she has two options. One is to wait to be a retiree, but this is a young person.
I see, okay. Look,
the other one is using the fact that her children are US citizens under 21. So she's asking if one is shorter, can she use one or the other?
Well, you have to wait and look. First of all, your child can't sponsor you until he or she is over 21. And that's always going to be less time in the next few years than a retiree case. So that's up to you. Your kids can't do anything until they're 21 anyway, so you can wait and see what visa numbers are like when that happens. But typically, you're always going to have a better outcome when you're being sponsored by a U.S. citizen. Might be a little shorter when visa numbers are available.
Someone else asks, can the possession of an A1 visa be combined with the G4 to meet the 15 years at the organization?
No, only G4 time. There's no other time that you can use under the special immigrant provisions, but G4 time. Not A, not G1, not G2, not G3, only G4.
Do you have to be in your home country waiting for the visa process, or can you live somewhere else? I think you mentioned that. You said that the person could live wherever.
Yeah, you can live whatever, but you can only process in your home country because I don't want to go into a long discussion here. It's not important, but the only place you have a right to process is in your home country. So if you're working overseas, that's great. You just go back to your home country. When you visa process, there's an interview date. It's not like you're sitting around. There's a specific day and time you go back to your home country for the medical and the interview. So that's fine.
Next one is, I would like to clarify if my spouse, who is a dependent on my G-4 for more than 7 years, can apply for residency. You already said no, right?
No, that's for children of that's the G-4 special immigrant children's provision, not for spouses. This question comes up a lot. Spouses cannot apply under the provisions for special immigrant. It's the principal, retiree, or the child. The spouse is only derivative of the retiree, or maybe if they're working in the private sector, they can be sponsored that way, or through a US citizen child who's over 21.
Thank you. Could you clarify? It went up because someone else put, there's more questions coming. Could you clarify how is the process for children with G-4 to apply for permanent residence, especially regarding age requirements?
The child has to be, the counting of the 7 years, I guess this is what you're asking, for this provision starts at the age of 5. So anytime they're here in the US at G-4 before 5 years old doesn't count. And the counting stops when they turn 22. So they have to have 7 years as G-4 kids between the ages of 5 and 22. And they also have to show that they've been physically present in the US. So the only time that is counted out for kids in terms of showing that they're physically present is if they go to school abroad or if the duty station of the parent has changed. So that time is counted out. But if your child is here and has been here 7 years, between 5 and before their 22nd birthday, then they can apply, at least they can file an I-360 now.
Okay. The OAS has a policy of mandatory retirement at age 65. If one does not have 15 years under the G-4 accumulated by that time, it is my understanding that even if one were to work as a consultant post-65 to acquire those missing months, this is not possible. Can you confirm this is correct?
Yes. Well, here's what's correct. You have to make your 15 years before the organization retires you. Okay, so if you're officially a retiree at 65 and you do not have 15 years, you cannot make it up as a consultant after that.
Thank you. If you're doing the visa processing, then you can come and go with a tourist visa to the US as many times as you want?
Well, let me clarify that too. You know, tourist visas are coming in on the visa waiver without a visa up to 90 days. This is all discretionary. Okay, you come to the port of entry, you're allowed in, but it's not mandatory. Nobody has to let you in. So you need to be careful. You can't just keep coming in and out, in and out. Your entries are tracked. You can't come in for 6 months, leave for a week and come back again. You're going to get thrown out potentially. Same with the visa waiver. You come in for 90 days. You can't go to Canada and then come back for another 90 days. You have to be careful that you don't abuse the visitor status, and if you do, and you don't want to be put on a plane and removed from the US. Okay, so no, you can't come in as many times as you want. You can come in, you should have a round-trip ticket, but you can't abuse it because you'll get in serious trouble with the people at the port of entry.
Thank you. Is a person that is changing its status from G-4 to permanent resident allowed to work while the permanent residence is issued? Does that person have to pay taxes, or they start paying taxes when they become permanent residents?
Okay, I cannot answer tax questions, so you'll need a tax expert for that. If you're changing your status from G-4 to green card based on being sponsored by U.S. citizen spouse or over 21-year-old child, and you're working at the OAS, you can still work at the OAS. You can't work anywhere else. You can still work at the OAS. While you're waiting for your green card, you will get, as I said, travel permission and work permission, a generic work and travel permission. Once you get that, you can work outside of the OAS in the private sector, but not until.
Thank you. If you retire today and start the process today, there will be a waiting period before you can set your green card. Can you still remain in the country, in the USA, during the waiting period with a work permit?
No, you're not going to get a work permit because, as I said at the beginning, the only way you can stay in the country waiting for the green card is if you can file the petition and change of status application to adjust status. You cannot do it now because there's no visa available that allows you to do the second step. So the answer to that question is no.
Yeah, if I understand correctly, I would want to make that emphasis because this change is what led to us having you give this.
Yeah, let me just restate it again because it's so important.
It is.
When you requested a green card or which is a visa, green card is an immigrant visa. Okay, if you're in the U.S., when you file, it's usually two pieces. The petition classify you as a retiree, and if there's a visa number available at that moment, you could file a change of status, what I call the adjustment of status application. Right now, there are only visas available for people who filed under the G-4 special immigrant provision prior to September 1, 2018, meaning that there's no visa number now for anyone who files today, okay? So you can't do the two pieces. You can only do the I-360 petition, but you can't file the change of status because there's no visa number that's available at this moment. And it's the change of status that keeps you legal in the US. A petition is not what makes you legal in the US, it's the change of status. And that's where the problem is, because the retirees who are living here for 30 years can't stay here because they can't do the second step, which is the change of status. And that's the horrible outcome of this regression.
So for everyone to understand and see if I understood correctly, before there was a possibility for people with a G4 for the last 15 years retiring from the OAS to start the application process and also request a special visa and remain. That option is no longer available as of now. It can change, but as of now, if I retire today, I can initiate the process, but I have my 30 days to leave the country or do something to extend it a little bit, right. But I have to leave the country.
Unless you have another way of staying here, that's correct. Every month, the State Department issues what's called a visa bulletin. It's called a visa, and everybody can have access to it. It's a public document. And the visa bulletin, I don't know if people can see this.
Yes.
It divides up the visas, family and employment. And you can see every month that, you know, where the line is, where the line has moved to, okay? So in previous years, the line for the EB4, which is where the special immigrants were, was C. C mean current. There were visas always available except for a few countries, Honduras, Guatemala, El Salvador. Now, the line that says September 1, 2018, meaning there are only visas available for people who filed their retiree cases before that date. And so you can just Google it. Just someone asked, can I share the link? Just Google visa bulletin. It will come up.
Okay.
And you can track every month, you can track where the visa numbers are. When this whole process started, when this change started, it was in December of 2022. In December of 2022, visa numbers regressed to, I think it was June of 2022. Okay, so it was like 6 months, not so terrible. Nothing changed in January, February. Then March was the same. Then we got April last week. And April, the visa numbers regressed all the way back to 2018.
Thank you so much, Linda. I don't know if you'll be able to answer these questions. You tell me. This one is very, very specific. It says, my wife has a small business in this country and a work permit via my G-4 visa. This permit is expiring this month. We will submit a renewal application for the coming months until my retirement, which is July 31st of this year. How can she continue to work with the projects that she has signed for if she cannot work after the date of my retirement?
Well, she can't. And not only that, if your work permission is is expiring this month, you're not going to get your work permission for a couple of months. You're going to have to stop working. Once you work, filing for the renewal does not allow you to keep working. So you have to stop working until the new work permission is issued. And so, you know, I don't know when that will be, but the other question is, once the retirement happens, what happens to the work permission? The work permission ends.
Okay, thank you. You mentioned that the U.S. Immigration Services does not differentiate between your time with G-4 visa as a consultant or as a staff member. However, it is important to consider that the criteria to be considered eligible to retire under OAS standards only consider the time as a staff member. That's a good point from Carolina from Human Resources Department. Thank you, Carolina.
Well, it's
an internal.
That's an internal decision. You know, the World Bank also doesn't consider short-term consultants time in G-4. So that's up to the organization.
Perfect. And I think though that's the end of the questions in the chat. I'm seeing the Q&A. Someone says, how long is the process for getting the green card and work permit through being married to a US citizen when you do the process abroad?
There is no work permit abroad. That's what I'm trying to explain. When you file in the United States called adjustment of status, while you're physically here, you're remaining here through the process, you get work and travel. You're in the US, you're living here, you're waiting here for the green card. If you go overseas and you visa process, in other words, you're not here, you're finishing the case through the US consulate abroad, you're not living here, there is no work and travel, you're not here.
Thank you. Someone asks if you could please explain more about the situation of someone who had previously a G1 and changed to a G4, hold the G4 for more than 15 years, and after retirement wants to apply for residency. If you have been with a G4 for 15 years and you retire from the OAS, the previous G1, the time with G1 shouldn't affect, right?
No, it doesn't. It's irrelevant. The only thing that's relevant is that you have 15 full years as a G4 and you meet, you know, the physical presence and resident requirements. Whatever other visa you had is irrelevant.
Perfect. And the last one I'm seeing is under the special immigrant provision, do I have to wait to be retired from my international organization to file the I-360 petition, or can I file it while I continue working with a G4?
That's a good question. You can only file the I-360 petition after you've retired. You're not a retiree until you've retired. There's no pre-filing. So you have to retire, you have to get the certification from the OAS that you've retired, and then you can file. You know, I mean, that's the requirement.
Okay. Well, thank you so much. There comes messages that now they are of thanks. This has been very, very informative. People have the website of your law firm. It has been distributed with the link to this meeting and the invitation. Is that a good way to reach you through your website?
Sure. And thank you for having me. I appreciate it. I know it's a dense topic. It's very important, and you know, I feel your pain because this is a terrible thing. I mean, so many of you lived here for so long and made plans, and now for, you know, because of poor public policy, here we are.
Yes. Yes, it is very unfortunate for people nearing retirement and with family here and for living here for 15 years or more to face this situation. That's why we invited you, and this is very valuable information. Thank you so much. And anyone who would like to contact Linda Hoffman, please reach out to her through her website. If you don't find it in your email, Marisol Prado has it, so you can always ask her.
Sure.
Thank
and
you.
we'll try to keep you guys updated on how visa numbers are going as an organization.
Thank you so much. We really appreciate that. Thank you.
Bye-bye.
Bye-bye.